Ready, start. Here, there are further findings that the contraption was indeed driven negligently at high speed, resulting in an accident leading to the victim's death. Stop. In the face of these facts and position of law, the charge of causing death by negligence is well established against the revisionist. So far as the evidence under Section 279 IPC is concerned, that on evidence 2 is proven beyond doubt. Stop. There is no scope for interference with the findings of the two courts below who are ad idem about the revisionist's guilt. Stop para. Now turning to the question of sentence, Mr. Srivastava, learned senior counsel, appearing for the revisionist, submits that it is not a case where anything was intentioned by the revisionist. Stop. He was himself the driver of the vehicle, and what happened was a pure accident. Stop. Looking to the nature of the vehicle that the revisionist employed to venture out on the roads, and the evidence about negligence forthcoming against him, this court does not think that the revisionist is entitled to leniency in the matter of sentence. Stop. Accident on roads that are caused by rashness or negligence are a specie of pernicious conduct that has devastating consequences for not only for the victim but the entire family. Stop. It is an offence which impacts the society by rendering women destitute, children orphans, and old parents staring at the darkness of a last progeny just on the rush of adrenaline, capturing the man who maneuvers the steering of a motor vehicle and presses the accelerator. Stop. Here the case is worse because the vehicle involved is one that never to have been fabricated, much less driven in public place. In this connection, it would again be relevant to mention the authority of the Lordships in Balwinder Singh supra were adopting a different stance in sentencing in matters of rash and negligent driving. It was held para. Even a decade ago, considering the galloping trend in road accidents in India and its devastating consequences, this court in Dalbir Singh versus State of Haryana 2005 SCC 82 held that while considering the quantum of sentence to be imposed for the offence of causing death by rash and negligent driving of automobiles, one of the prime considerations should be deterrence. Stop para. A professional driver should not take a chance thinking that even if he is convicted, he would be dealt with leniently by the court. The following principles laid down in that decision are very relevant. Stop. When automobiles have become death traps, any leniency shown to drivers who are found guilty of rash driving would be at the risk of further escalation of road accidents. All those who are manning the steering of automobiles, particularly professional drivers, must be kept under constant reminders of their duty to adopt utmost care and also of the consequences befalling them in cases of dereliction. Stop. One of the most effective ways of keeping such drivers under mental vigil is to maintain a deterrent element in the sentencing sphere. Stop. Any latitude shown to them in that sphere would tempt them to make driving frivolous and a frolic.